motion was filed on the 3rd of November.
Yes, my lord.
Court application granted.
As court pleases, my lord, I sincerely
Time is
apologize.
the written address of claimant filed on the 3rd of November 2025 is deemed as properly filed and served.
As the court
As
pleases.
court pleases.
Good, my lord.
Yes, defense.
My lord, will require 14 days to conclude our final address.
We pray for another date.
As my lord pleases.
Will the 25th of February be convenient for adoption?
Convenient, my lord. Yes.
25
Convenient, my
February.
lord.
Court cases adjourned to the 25th of February 2026 for adoption.
As the court pleases.
Thank you.
Thank you, my
So
lord.
Thank you, my lord.
I should congratulate you for succeeding in joining virtually.
Thank
As
you.
the court pleases. Thank you, my
The
lord.
both of
Thank
you
you.
that have been struggling with joining the virtual proceeding.
We'll do better.
We'll do better next time, my lord.
Well, that
Thank
is, if it isn't required, it's just because of the circumstances that I had to bring all these cases online. Have a good day. Bye.
Thank
Yes.
you, my lord.
LKJ. Dada.
Whoever is not online should please mute their device, please, so that there won't be interruption. Thank you. So we called Suleiman Dauda now. Is that the case?
Yes,
My lord.
Yes, appearances, please.
May it please me, Lord. I am A.O. Onoja. My appearance is for the judgment creditor applicant.
Yeah. Or not just for judgment creditor applicant.
With respect to this honorable court,
Yes.
I'm Gio Salifu,
Yes.
appearing with M.A. Abejiri for the judgment debtor respondent.
Yes.
Yes.
My lord, sir.
Yes.
My name is E.A. Mejabi.
Yes.
I appear for the applicant, sir.
Yeah, thank you. Ruling. I have carefully examined the motion on notice, hearing filed on the 10th of March 2025 by which the judgment creditor applicant is praying the court for the following principal reliefs, namely, 1, leave of this honorable court to proceed against the principal or executive officers of the judgment debtors who are corporate bodies. 2, an order of this honorable court for committal to prison, the contemptors in this contempt proceedings for having neglected to obey the order of this court made on the 28th day of July 2022, requiring the contemnant to reinstate the judgment creditor applicant to his job forthwith by the contemnants, as ordered by the Honorable Court. 3, a declaration that failure on the part of the contemnants to give effect to the order of reinstatement of this Honorable Court, delivered on the 28th of July 2022, and same being served with Form 48, constitute contempt and an attempt to undermine the authorities, and all powers of this Honorable Court guaranteed by Sections 1, 6, 254, 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and affronts to judicial processes and rule of law. 4, a declaration of the refusal of the Rector of First Judgment Debtor and the Attorney General of Kogi State principal officers of the contemnants and whosoever responsible to give approval, order, and/or directs the obedience of the order of reinstatement to take all lawful steps to obey the enroll order of NICN, Lokoja Division, Judicial Division, delivered on the 28th of July 2022, as furnished them is unlawful and illegal, and affronts to the authority of the court as such. Conduct constitutes a contravention of the provisions of Section 1, 6, 13 to 17, 91, 112, and Paragraph 5A, Part 1, the third schedule of the 1999 Constitution of the Federal Republic of Nigeria as amended. The application is predicated on 5 grounds, and in support thereof is an affidavit of 21 paragraphs to which a document was annexed as exhibits. Also filed alongside is written submission of counsel. In opposition, the judgment debtors, contemnants, filed a counter affidavit of 5 main paragraphs on the 14th of April 2025. Also filed alongside is the also filed with the counter affidavit is the written submission of their counsel. It should be counter affidavit, but it is titled affidavit, was filed by the judgment debtors, contemnants, on the 15th of May 2025, to which 4 documents were attached as exhibits. It was said that the exhibits were inadvertently unattached to the counter affidavit that was earlier filed. On the same 14th of April 2025, the judgment debtors, contemnants, also filed a notice of preliminary objection, praying for an order of this honorable court, striking out the applicant's motion for committal as being incompetent, premature, and improperly constituted. The grounds upon which the objection are as follows. The grounds are stated on the face of the ruling. To save the time of the court, I will skip the reading thereof. We have 7 of the grounds stated. In his argument, counsel for the contemnants, F.O. Ekpa Esquire, made reference to Order 26 Rules 3 and 4 of the rules of this court and the authorities of Enigbo Con versus American International Insurance Company, Nigeria Limited, 1994, 6 Nigeria Weekly Law Report, Part 348 of page 1, and submitted that any person who is not party to a suit cannot be held liable for the outcome of the judgment in the said suit, that all parties who will be affected by the litigation must be made parties and be heard before judgment is delivered, that a party cannot unilaterally amend the processes without leave of court, and the alteration of the second judgment debtor from Kogi State government to Kogi State Attorney General without seeking and obtaining the leave of court renders the entire committal proceeding a nullity. In reaction, the judgment creditor applicant filed an affidavit of fact on the 22nd of April 2025, and counsel's written address was also filed alongside. In another vein, a motion on notice was separately filed by the Kogi State Attorney General on the 19th of May 2025, praying for an order of this honorable court to set aside Form 48 and Form 49, respectively, issued against the applicants, that is the Attorney General, who was not a party in suit, number NICN LKJ 333-2020. The motion on notice is premised on the following grounds. Again, to save the time of the court, the grounds upon which the motion was the motion is premised are stated on the face of the ruling. We have 7 of such grounds. The argument of counsel E.A. Mejebi is that the applicant was not party in the judgment delivered by this court in suit number NICN/LKJ/33/2020, that without leave of this court, the judgment's creditor brought in the applicant as the second contemnor and further issued Form 48 and Form 49 against the applicant, that any person who is not a party to a suit cannot be held liable for the outcome of the said judgment, that an agent of a disclosed principal cannot be held for an act of the disclosed principal, that for a party to be held in contempt of court, there must be an order specifically made against such person, and therefore urge the court to hold that there exists no right accrued to the judgment creditor against the applicant to warrant the hearing of committal proceedings. Counsel thereby urged the court to strike out Form 48 and 49 as an abuse of court process. The cases of Achibong and another versus Oko, Banwatz and another versus Association of Medical Laboratory Scientists of Nigeria and others, Igbeke versus Okadigbo, citation all supplied, were entirely cited to support as propositions. The counsel for the judgment creditor respondent in his reply on point of law made reference to Order 13, Rule 14 of the Rules of this Court, Section 195 of the Constitution of the Federal Republic of Nigeria, and pages 1 and 3 of the judgment of the court delivered in suit number NICN/LKJ/33/2020, and submitted that the Attorney General has not been denied fair hearing by making him a party in the contempt proceedings filed by the judgment creditor. It is the further submission of the counsel that this honorable court has refused to set aside Form 48 in its ruling delivered on the 6th of March, 2025. The appropriate takeoff point in the determination of the objections is on the submission of A.O. Onoja Esquire, counsel for the judgment creditor applicant, that the filing of both notice of preliminary objection and a counter affidavit of the judgment debtor's objections amounts to an abuse of court process. I do not agree with that submission. This is so because the respondent, the judgment debtor, in this instance, served with a motion on notice and intends to oppose the application must by law file a counter affidavit opposing the facts deposed in the applicant's affidavit. Where applicable, he must also file a written address to canvass arguments why the application should be refused. It does not, by the filing of a counter affidavit, lose his right to file a notice of preliminary objection to oppose the application on points of law and to seek the striking out of the application. His position can be likened to that of a defendant filing a statement of defense and also filing a notice of preliminary objection to have the suit struck out for incompetence. The cases of Dowell Schulberger Nigeria Limited versus Eneco and CSA Industries Limited versus FBN PLC, number 1, citation supplied, as cited by counsel, are not relevant to the facts of this case. In Saddam and Co versus NDIC and others, 2018, Law Pavilion Electronic Law Report 46569, it was held that filing both notice of preliminary objection and counter affidavit as proper. See also the case of Honeywell Flour Mills PLC versus EcoBank Nigeria Limited, 2016, Law Pavilion Electronic Law Report 40211. I am not aware of any provision in the rules of this court that prohibits a respondent to an application from filing both a counter affidavit and a notice of preliminary against the hearing of the motion itself and or the grant of the prayer sought. In the circumstances, therefore, the argument of counsel for the judgment creditor applicant is hereby not countenanced. By my understanding, The basis of the notices of preliminary objection filed separately by the judgment debtors and the Attorney General as the applicants is that parties in the content proceedings filed by the judgment creditor as judgment debtors and or the Attorney General as the second contemnor were not parties in the said judgment delivered by the court in suit number NICN/LKJ/33/2020. Invariably, both notices of preliminary objection are praying the court. Both notices of preliminary objection is praying the court to strike out the contempt proceeding initiated by the judgment creditor for misjoinder of the Attorney General not being party to the judgment delivered by the court. With the greatest respect, the argument of respective counsel for the objectors that the Attorney General cannot be made a party in the content proceeding, having not been made a party in the substantive suit, is totally misconceived. It is imperative to understand the legal standing of the Attorney General. The Attorney General of a state is the proper and constitutionally recognized legal representative of the state government. By law, the Attorney General of the Federation or of the state represents the interests of the Federation or state in the cases in which the government, federal or state, or any of its agencies is sued. The authorities on this are replete. This issue appeared exhaustively explained in the case of Government of Imo State and another versus Ogo and others, 2015, Law Pavilion Electronic Law Report at 25949, where the court with regards to the functions of the Attorney General held as follows. I quote, Attorney General of the state is the chief legal officer of the state, enjoined by law to represent the interests and obligation of the government of Imo State in all legal or judicial transaction, and their roles are constitutional. See Section 1762 of the 1999 Constitution of Nigeria, which says the governor of a state shall be chief executive of the state. And Section 195 sub 1 says there shall be an attorney general for each state who shall be the chief law officer and commissioner for justice of the government of that state. There are several judicial interpretations to the effect that Attorney General of a state is a defendant or a nominal defendant in all civil actions which the government of the state is sued and involved, and the act or omission of the governor of the state or any official of the state when under litigation. End of quote. See also the cases of Nigerian Engineering Workers Limited versus DENNAP, the case of Attorney General Adamawa versus Attorney General Federation, the case of Attorney General Anambra State versus Attorney General Federation, and the case of Shuaib versus Attorney General Federation, citation also applied. It is elementary law that the Attorney General is the legal representative of the state. In every case, the state has an interest. Therefore, when a suit is filed against the state government, it is understood that the Attorney General, in their official capacity, is the proper defendant representing the interests of that state. The Attorney General's office is responsible for defending the state and, upon an adverse judgment, for advising the state on compliance and facilitating the enforcement process. Perhaps I should further state that by Order 63, Rule 2, sub 2 of the rules of this court, the service of motion or notice shall be notice for committal shall be on the person or the counsel to the person or on any principal of the body sought to be committed. Consequently, a judgment delivered against the state government is a judgment against the state as a corporate body, and by extension against the office of the Attorney General who represent that body. It is equally borne by the records of this court that Kogi state government, that is the second defendant in the substantive case, was legally represented by state counsel, that is counsel for the office of the Attorney General. as correctly submitted by counsel for the judgment creditor, I do not lose sight that this court had refused the application of the judgment debtors to set aside Form 48 and its ruling delivered on the 6th of March 2025. The present application by the applicants, praying for the same order to set aside the Form 48, is not only incompetent, but an abuse of court process. Based on the foregoing, the notice of objection of judgment, the notice of objection of the applicants, that is the Attorney General, of 19th of May 2025, which is purely a misjoinder of the Attorney General, is hereby accordingly dismissed.
All places.
Now,
As a
the further submission of counsel for the contemnors, that is FO ECPA, in its preliminary objection of 14th of April 2025, is that the applicant did not follow the proper procedure and mode of commencing committal procedures and urged the court to strike out the committal process for want of jurisdiction. Counsel made reference to Order 9, Rules 13.1 and 2 of the Judgment Enforcement Rules and submitted that the applicant is in flagrant disobedience of the procedural steps in commencement of contempt proceedings by issuing Form 49 together with the motion for committal in the manner prescribed by the rules and urged the court to hold that the judgment creditor has vitiated the entire proceedings and thereby lacked the jurisdiction, and thereby the courts lacked the jurisdiction to entertain the case. In reaction to this objection, counsel for the judgment creditor applicant had strenuously argued that the filing of both notice of preliminary objection and counter affidavits simultaneously by the contemnors is an abuse of court process. Counsel for the judgment creditor did not respond to the germane issue that the committal proceedings was initiated without following due process of law. I had earlier held that the filing of notice of preliminary objection and counter affidavits in the instant case is proper. I should further state that the notice of preliminary objection raised purely legal issues. As such, the affidavit of facts filed by the judgment creditor is needless and hereby discountenanced. The contention of the judgment debtors contemnor is that the applicants did not comply with the procedure prescribed in Order 9, Rule 13.1 and 2 of the Judgment Enforcement Rules in initiating committal proceedings, that the judgment creditor ought to have waited for at least 48 hours after the service of Form 49 on the judgment debtor before filing the motion for committal, that Form 49 was issued and served together with the motion for committal, and that without strict compliance of the rules, the court lacks jurisdiction to proceed with the present committal proceedings. Now, it is settled that contempt or committal proceeding is quasi-criminal proceedings which has the likelihood of affecting the liberty of a citizen. Against this background, as correctly submitted by counsel for the judgment debtors contemnors, every procedural step must be followed strictly. See the cases of Okobi versus Moniru, FCDA versus Kuripabo Agri, citations supplied. The law is equally established that where a statute provides for a particular method or manner of performing a duty or an act regulated by the statute, be it substantive or procedural, that method and no other should be the one to be adopted in the performance or conduct of the stated duty or act. See the case of CCB, Nigeria PLC versus Attorney General of Anambra State and another, 1992, 8 Nigeria Weekly Law Report, Part 261 at page 529. I have undertaken a careful perusal of the processes filed by the judgment creditor the notice to show cause, why the order of attachment or committal should not be made, that is Form 49, was filed on the 10th of March 2025, and by the affidavit of service, the said Form 49 were respectively served on the Secretary to Registrar Kogi State Polytechnic, one and one Sonny James of the Ministry of Justice, Lokoja, on the 11th of March 2025. It is clear that the judgment creditor did not comply with the procedure prescribed by the rules in the instant committal proceedings, and I so hold. In the circumstances, therefore, having failed to strictly comply with the prescribed procedure of initiating the committal proceedings, the court lacks the jurisdiction to entertain same. In the event the objection on this issue is upheld, the case is hereby accordingly struck out. Parties shall bear their respective costs.
As court, please.
My Lord, we are very grateful, my Lord.
Yes, can I have the second case for the ruling?
We are most grateful, my Lord.
My Lord, we are most grateful.
That's number 4. NICN LKG 23-2026 between Charity Lati Oluto and Kogi State Government and 2 others. Parties absent.
Parties absent, appearances, please.
May it please me, Lord. I am here on Onoja. My appearance is for the claimant applicant.
With
Yes.
respect to this honorable court, I'm G.O. Salifu, appearing with M.A. Abejiri for the defendant's respondent.
Ruling.
As court pleases.
I have carefully examined the applicant's application hearing by which he is praying the court for the following principal reliefs. 1, leave or order of this honorable court to join Shadrach Zekari, Peter A.J. Adamu, Aminat Yusuf as co-claimants in the suit as person having same interest in this case with the original claimants. 2, leave of an order of this honorable court to amend claimant's complaint. The application is supported by a 12-paragraph affidavit with a proposed amended complaint annexed as Exhibit A. Also filed alongside the written address is the written address of counsel to the applicants. I have proceeded to carefully consider this application, the facts deposed in the affidavit filed to support the same, including the documents annexed as exhibits thereto. I'd also taken cognizance of the facts deposed, the counter affidavit to oppose the application on behalf of the defendant, deemed filed on the 14th of October 2025. I've also taken due benefit of the totality of the written and oral submissions canvassed by respective counsel in support of their positions. As gleaned from the facts in the affidavit filed by the claimants to support the instant application, it is deposed that the parties seeking to be joined are necessary parties, that due to inadvertence at the time of filing the suit, the documents were mixed up in other files, that the case will not be completely and effectually determined without joining the said parties, and that by this application, they also seek to regularize the processes by bringing in facts and documents for the determination of the case. In the written submission, the counsel for the defendants in reaction restated the tried position of law that parties seeking to be joined in an existing suit must establish that he is either a proper party, desirable party, or a necessary party, in the absence of whom an effective or complete determination of the suit will not be attained. The summary of the arguments canvassed by counsel is that parties seeking to be joined in the instant application have failed to establish that they are necessary parties and that they are questioned in an action that cannot be effectually and completely settled unless they are joined as parties. On the relief for amendments of the complaint, the further argument of defendant's counsel is that the prayer for amendments has failed on the ground that the application did not emanate from the claimant and that sufficient reason was not stated in the affidavit for the consideration of the court to grant the amendments. On the principles guiding the grant of application for amendments, counsel cited inter alia the cases of Uwagu versus INEC, Clean Line Investment Limited and another versus PZ Industries Limited, Union Bank Limited versus Ogbo, citation also applied, and argued that the applicants introduced new facts and new course of action that changed the nature of the claims, which will require fresh processes to be filed. He finally urged the court to refuse the application. Now the principles governing the joinder of parties, whether as a claimant or defendant to an existing action, or whether the application is made by the claimant or defendant in the said existing action or by an intervener, are no longer recondite. Indeed, the law reports as replete with cases in which the principle governing the joinder of parties have been enunciated. Permit me to refer to some of the cases. In Ige versus others versus Ige and others versus Faraday and others, 1997, Nigeria Weekly Law Report, part 35442, the court stated that the purpose of joinder of a party to a pending action are one, to put an end to litigation and not to have parallel proceedings in which the self-same issue is raised, leading to different and inconsistent results. Two, for the person joined to be bound by results of the litigation. The case under reference also brings it out clearly that an applicant seeking to join a pending case has the duty of satisfying the court that he is a person who ought to have been joined in the suit in the first instance, or that his presence before the court is necessary to enable the court to effectually and completely adjudicate upon and settle all issues involved therein. Again, in the case under reference, it was said that the main question for determination in application for the joinder of a co-plaintiff or co-defendant is whether or not the applicant in question is a necessary party, and the court will order the joinder once the presence of that person is necessary to enable the court effectually and completely adjudicate upon this and settle all the questions involved in the cause or matter. Finally, in the case on the reference, it was said that it is desirable that intending co-plaintiffs should make sure that there is no conflict of interest or any division of opinion between the original plaintiff and themselves is likely to arise. This is because co-plaintiffs will not be allowed to serve or take inconsistent steps, and that they ought to be represented at the trial by the same solicitor or counsel. See also the cases of Rinco Construction Company Limited versus VP Industry Limited and another. The case of Meducam versus Egemole. The cases, citation supplied. The cases of Azubike versus PDP and others. The Governor of Ebonyi State and another versus Andrew Bishopton Limited and others. OK Contact Point Holding Limited versus Progress Bank of Nigeria PLC and another. Citation also applied as cited by respective counsel opposite. On the basis of the applicable principles, the focal question that calls for the resolution, therefore, is whether in view of the facts as presented, the applicant is entitled to the grant of this application for joinder of the person sought to be joined as claimants and for amendment of the complaint and statement of facts as being sought. It is pertinent to state at the outset that in line with the authorities cited earlier, it is provided in Order 13 Rule 1 of the rules of this court that all persons may be joined in one action as claimants in whom any right to relief is alleged to exist, whether jointly or severally, and judgment may be given for such claimants or claimants as the case as may be found to be entitled to the relief or reliefs. Pursuant to Rule 7 of Order 13, a claimant may, at his option, join as parties to the same action all or any of the persons severally or jointly and severally liable on any reliefs in the matter. The purpose of this rule is to forestall parallel proceedings in which there are self-same issues and also to properly and effectually resolve the issues in a suit. Having appraised all the facts put forward by parties in the present application, I do not agree with the arguments of the defendant's counsel that the applicant has not disclosed the facts that the parties sought to be joined have common interest and that they are necessary as co-claimants to resolve all the issues. Or put differently, the interest of the parties sought to be joined has been disclosed for the court to join the said parties in order to be bound by the outcome of the case. And I shall further state that Order 13, Rule 14.3 of the Rules of this Court provides that the court has the discretion where it appears to it to add any party whose presence before the court is necessary to effectually and completely adjudicate and settle the questions involved in the proceedings. In other words, the court, even without the application of parties, that is suo motu, is entitled at any stage of the proceedings to join in an action, whether as claimant or defendant such parties, in its considered estimation, who may be possibly interested in an action, or in the case of a potential defendant against whom the right to a relief is alleged to exist in the claimant's claim. Based on the foregoing, I am in no doubt the parties sought to be joined will likely to be affected by the decision of the court. In the circumstances, therefore, the application for joinder is hereby granted. The parties sought to be joined, that is Shadrach Zekeri, Peter Eje Adamu, Aminat Usman shall respectively be joined as second, third, and fourth claimants in this case. On the prayer 2 for amendments of complaints and statements of facts, it is settled that amendments is usually directed to the correction of blunders, errors, and or inadvertence of counsel. It may also be granted where the pleading is intended to be brought in line with evidence already laid on the record. However, the court is obliged to refuse to grant an application for amendment where it will have the effect of overreaching or will result in injustice to the other party, or where it is brought mala fide, or where the amendments will alter the nature of the case as considered by the court. See Kode versus Yusuf, 2001, for Nigeria Weekly Law Reports, part 703 at page 392. The court will also not grant an application for amendments which, if granted, will unduly delay the hearing of the suit or unfairly prejudice either party to the suit. The court will not grant an amendment to change the nature of the claims before the court or where it will create a suit where none existed. Leave will not be granted. Okolo and others, and another versus UBN Limited, and Alston SA versus Saraki citation supplied. In determining this application for amendment, it is important to bear in mind that leave to join second, third, and fourth claimants was made simultaneously with the leave for joinder. With the leave for amendments, excuse me. This is more imperative because the defendants have loudly complained that the applicants merely seeks to change the nature of the claims before the court, and granting the amendment will unfairly prejudice the defendants. As correctly submitted by Defendants Counsel, the facts as stated in paragraph 2C of the application proposing to introduce new paragraphs 31 to 35 to capture the new minimum wage being currently paid in the proposed amended statement of facts will change the nature of the claims before the court and agree that the defendants will ultimately be prejudiced. This leg of the proposed amendment is hereby accordingly refused. On the other hand, having granted the prayer for joinder of Shadrach Zekari, Peter Eje Adamu, Aminat Yusuf as second, third, and fourth claimants, it is my view that the claimants should be allowed to bring to fore the facts they consider germane to a just determination of a suit, so long as the rights of the adverse party is not infringed, and so long as it is not shown that the amendment is sought to overreach the adverse party. Prayers 2A and B, in my view, are facts to be considered in a just determination of the suit, and are accordingly granted. In totality, leave is hereby granted to amend the complaints and statements of facts as follows. 1. To reflect the names of the said claimants and rephrasing some of the paragraphs of the pleadings to accommodate the parties joined. 2. To delete 1. The phrase August 2024 and replace with the word to date. B. 186 months in paragraph 18 with 208 months and about 17 years. C. Old paragraph 5, B, C, D, and I of the statements of facts. C. To rephrase paragraphs 26 of the statement of facts with phrase of arbitrary, wrongful, or and suspension. B. Paragraph 46, 48, 50, and 52 of the statement of facts by introducing suspension and to justify withholding of salary. The amended processes bearing the names of the said claimants and the amendments as granted shall be filed and served on all the defendants within 7 days. Parties shall bear their respective costs.
As the court pleases.
I believe that you will have a better understanding of this ruling where you get the copy, because like I stated, one of the leg of the amendments was not granted. So I had to write the parts that will be amended. So while the claimant's counsel is considering, it should check with the ruling to see what parts of the amendments is granted. Thank you.
As the court pleases.
So we have the other ruling now.
Case number 5, NICN LKJ 15/2024 between Mercy A. David and 6 others, and Kogi State Government and 2 others. Parties absent, my lord.
Appearances. Appearances.
Please, my lord,
Yes.
I am A. Onoja. My appearance is for the respondent.
Yes.
It pleases your lordship. My name is Oluwafemi O. Adegboyega. I appear with my learned friend V.A. Shaibu. My lord, we both appear for the applicants, the objectors in this matter. I'm most grateful.
Ruling.
Stop, places.
The instant notice of preliminary objection filed by the defendants on the 26th of March 2025 is brought pursuant to Section 2A of the Public Officers Protection Act, that is the POPA, and Section 18 of the Limitation Law of Kogi State 1991, by which they pray for an order of this Honorable Court dismissing or striking out the suit for being started bad. The preliminary objection is supported by a 5-paragraph affidavit, and it is premised on 3 grounds. Also filed alongside the notice of preliminary objection is the written address of the defendant's counsel. In opposition, the claimants filed a counter affidavit on the 2nd of April 2025, and a written address of their counsel was also filed alongside. In summary, the claimant's case is for the stoppage or removal of their names from the payroll of the defendants, and that without first determining the subsisting employment relationship, and without first determining the subsisting employment relationship, that the action of the defendants is unlawful, unconstitutional, and an infringement of the regulation governing the conditions of their service as public servants. Being thereby aggrieved, they instituted the present action against the defendants, claiming severally and jointly the relief set out as follows. To save the time of the court, the reliefs as contained on the face of the ruling. We have 8 of the reliefs. I have proceeded to carefully consider this application and the facts deposed in the affidavit filed to support the same. I'd also taken due benefit of the totality of the written and oral submission canvassed by respective counsel in support of the position they held. The argument of the counsel for the defendant, Oluwafemi O. Adegboyega Esquire, is that the claimants commenced the present action against the defendants after the time permitted by the POPA, Supra, and the limitation law of Kogi State, 1991, for filing an action against acts of a public officer complained of. The time for instituting a case founded on contract had elapsed. The defendant's counsel argued, the defendant's counsel argued that the claimant's cause of action, which stems from the alleged removal of their names from the payroll and alleged non-payment of their salaries, arose on the 31st of May 2009, became extinguished by the 31st of August 2009 and 31st of May 2014, respectively, whilst the instant action was only instituted on the 9th of May 2024. Counsel argued that the alleged acts of the defendants was done in pursuance of law, public duty, and authority, citing the cases of Egbe versus Adefarasi, UBN versus Oki, Nwadiaro versus Shell Development Company Limited, and Mercantile Bank versus Fateco, Ibrahim versus JSC, and Edo Sowan versus ACB Limited. Counsel submitted that limitation laws prevents claimants from litigating stale claims after undue delay to protect defendants from indefinite threat of litigation, as well as to ensure fairness. Counsel finally urged the court to hold that it lacked jurisdiction to entertain the suit for being statute barred. In reaction, counsel for the claimants made reference to paragraphs 8, 17 to 22, 48, and 50 of the statement of facts, and argued that the action of the defendants are unconstitutional as they have acted outside the statutory or constitutional duty, and further argued that such action in breach of section 33, 36(1), and 44(1) of the Constitution of the Federal Republic of Nigeria, 1999, is not defeated by limitation statute, that limitation laws do not apply to action founded on rights enshrined on Chapter 4 of the 1999 Constitution, and contends that the right to fair hearing and fair trial is sacrosanct. The provision of Order 3, Rule 1, of the Fundamental Rights Enforcement Procedure Rules 2009, the case of Elf Petroleum versus UWA 2000 were cited in support of its proposition. The further argument of claimants' counsel is that Section 2A, Public Officers Protection Act, allows exception where there is continuance of damage or injury. The injury in the instant case is continuing until 2039 and 2040. The acts founded from malice, abuse of powers, illegal action of officials, or wrongful actions such as arbitrary withholding of salary, as in the instant case, does not enjoy the protection of limitation law, and further submitted that limitation act or law is inapplicable to the cases founded on contract. The cases of AG Rivers versus AG Bayelsa, Nestelo Gateway Group Limited versus JSC FCT Abuja, NRMAFC versus Johnson, Lagos City Council versus Ogumbi, KSJSC versus Tolani, Ibeto Cement Company Limited versus Attorney General were cited to buttress the submission. Counsel finally urged the court to hold that the claimant's case falls within the exception to the applicability of Section 2 A POP and the Limitation Act, and sufficient facts has been disclosed by the claimants that the action of the defendants are arbitrary, an abuse of power, mala fide, and further urged the courts to dismiss the defendant's objection for lacking in merit. It will seem from the submission made by respective counsel that they are not in doubt that the issue of court jurisdiction is the bedrock of a case. It is now settled that the issue of jurisdiction is fundamental to the question of the competence of the courts adjudicating. It is an exhibition of wisdom to have the issue of jurisdiction or competence determined before embarking on the hearing and determination of the substantive matter. See the cases of Uji and others versus Governor of Imo State and others, Dangote General Textile Products and others versus Ascon Associate Nigeria Limited and another. Suffice it to quickly affirm the tried position of law as correctly articulated by respective counsel, that in the determination of subject's matter or course of action in a suit, it is the originating process of the claimant that determines the jurisdiction. See Oloruntoba Oju and others versus Dokwamu and others, Oladipo versus NCSB, NURT and another versus RTEAN, citation supplied. The case of the claimants as disclosed in the statement of facts is that they were employed as officers by the third defendants on different cadres at various times from February 2003 and sometimes in 2005. However, they allege that the third defendant arbitrarily removed their names from the payroll and stopped their salaries and allowances in the month of May 2009 till date. The claimants contend that they have never been indicted for any wrongdoing or invited for investigation on any subject matter, and thereby maintained their employment still subsists with the defendants. In the famous decision of Thomas versus Olufosoye, 1985, 3 Nigeria Weekly Law Reports, Part 13, at 523, a cause of action is said to arise and accrue to the person entitled to it when the facts and all the facts are complete, which entitle a person to a remedy against another, if proved. The intendment of the doctrine governing the calculation of limitation period as encapsulated in Section 2A of the POPA is to preserve the orderly administration of justice and the law on the limitation period for bringing an action against a public officer is settled beyond doubt by a plethora of judicial authorities. The general position of law is that time begins to run for the purposes of limitation law from the date the cause of action accrues. See the case of Ajayi versus Adeniyi, Grave Holding Incorporated versus FGN, citation supplied. The simple and narrow question to be determined in the present application is whether the provision of Section 2 of POPA Supra and Limitation Law Supra applicable to the facts of this instant case to oust the jurisdiction of this court for being statute bar and liable to be dismissed. The defendant's counsel had contended that the claimant's suit was statute bar, having been instituted beyond the 3-month limitation period prescribed by the POPA and or 6 years limitation period of the law. Conversely, the claimants admitted that the suit falls within the exception of instituting an action as provided by the POPA, the alleged injury or damage caused by the defendants having been continuous. Now, the provision of Section 2 of the Act in focus in the instant case has been given interpretation in a long line of decided cases that are notoriously recondite on the question of the applicability of the POPA to employment contracts. This is because of the rapidity of the conflicting decisions emanating from the Superior Courts of Records of this country on the issue. Counsel for the respective parties have elaborately furnished some of this decision of the apex court, and as at the time the notice of preliminary objection was filed, was argued, the latest decision of the apex court in 2025 was the case of Anonam versus FUT, Owerri, 2025, Law Pavilion Electronic Law Report at 827. And the most recent decision of the Supreme Court on the vexed issue of the applicability of the POPA and limitation law is the case of Okoronkwo versus INEC, 2025, 8 Nigeria Weekly Law Report, part 1991 at page 131. In that case, it was held that that Section 2 of the Public Officers Protection Act applies to contracts of service, as in the instant case, thereby entitling the defendants to exercise their statutory rights and duty. Now, the doctrine of judicial precedent, otherwise known as stare decisis, is not alien to our jurisprudence. It is a well-settled principle of judicial policy, which must be strictly adhered to by all lower courts. While such lower courts may depart from their own decision reached per incuriam, they cannot refuse to be bound by the decisions of higher courts, even if those decisions were reached per incuriam. The implication is that a lower court is bound by the decision of a higher court, even where that decision was given erroneously. In Atolagbe versus Awune, 1997 9 Nigeria Weekly Law Report, part 522, page 356. Excuse me, page 536 at 564, Uwe's CJN, as it then was stated thus. I quote, "It is now settled that under the common law doctrine of precedent or stare decisis, the decision of a higher court may be criticized by the judge of the lower court, but notwithstanding the criticisms, the judge of the lower court is bound to follow and apply such decision in the case before him. He has no right to disregard the decision or sidetrack it." End of quote. The provision of the Section 2A of POPA provides that no action, prosecution, or proceeding shall lie or be instituted against any person for any act done in pursuance of execution of any law or public duty unless it is commenced within 3 months of the date on which such course of action accrued, in the instant case in May 2009, when the claimant's name were purportedly removed from the payroll and their salary stopped. It is crystal clear that the course of action arose when the claimants became aware of the alleged action of the defendants, and the suit instituted on 9th of May 2024 by the claimants is indeed statute barred. The right of the claimants to allege the action of the defendants became extinguished the moment they neglected to challenge the said action of the defendants within 3 months as stipulated by law, and are so hold. One of the principles of the statute of limitation is that a person who sleeps on his rights should not be assisted by the court in an action for his claim. A person who is aware of his rights but allows them to go stale should not be allowed to revive the said stale action to the detriment of an adversary. It is similar to the equitable principle that equity aids the vigilant and not the indolent, and it prevents a party from acting unconscionable. See Nwajora versus Shell Petroleum Development Company Limited, the case of Shell Petroleum Development Company of Nigeria versus Amadi, citations supplied. The philosophy behind the limitation law was stated by Toby J. Siaziden was in Mercantile Bank, Nigeria Limited versus Vateku, 1998, 3 Nigeria Weekly Law Report, part 540, page 143 at 156 to 157 thus. I quote, "A statute of limitation is designed to stop or avoid situation where a plaintiff can commence an action anytime he feels like so doing, even when human memory will have normally faded and therefore failed. Putting it in another language, by the statute of limitation, a plaintiff has not the freedom of the here to sleep and slumber and wake up at his own time to commence an action against the defendant. The different statutes of limitation, which are essentially founded on the principles of equity and fair play, will not allow such a sleeping or slumbering plaintiff." End of quote. On the basis of the foregoing analysis, therefore, in view of the principle of stare decisis by which this court is bound, the decision I arrived at is that the filing of the complaint 16 years after the cessation of the acts complained of clearly offends Section 2A of the Public Officers Act. I find in the result that this court lacks jurisdiction to entertain the suit. The same shall be and is hereby accordingly dismissed. Parties shall be at safe cost.
As the court pleases.
As God pleases. I'm most grateful, my Lord.
My Lord,
Well,
we
the
are
fact
most-
is that once the Supreme Court changes their position again, we all swim along with the Supreme Court. So that
Well, I
is
won't
the
go for the
situation in which we are presently with regards to the POPA. So we are bound by the decision of the Supreme Court, and there's nothing we can do about that.
as
Well,
the
I'm
court
most
Thank
grateful,
you.
my Lord.
My Lord, we are most grateful for the well-considered ruling. We are most
It will be
grateful.
well considered, Mr. Adegboyega now. The other one that was against it was not well considered.
No, my Lord, we have, my Lord, whether or not we agree with your Lordship's ruling, they are all well considered.
Well, that is the
We are
end of
most
the
grateful,
sitting
my
for
Lord.
today. Thank
We
you.
are most
Thank you for
grateful.
bearing with the court. I had to bring in this because we had so many seminars, conferences, and so it has disrupted the diary of the court. So I had to devise this method to be able to deliver the rulings.
Well,
I apologize for any inconvenience this must have caused. The court will rise now. Thank you.
most grateful.
Okay, the
I'm
rulings
most
will
grateful,
be
my Lord.
made available as soon as I can. I will forward both the files and the rulings before next week by God's grace. Thank you.
As the court
The court
pleases.
will
We are
I'm
most
rise.
most
grateful.
grateful, my Lord.